Welcome to This Explainer. Okay, we're diving straight in today. So imagine this. You've just spent months, maybe even years, wrapped up in this incredibly complex commercial dispute. You decided to go with arbitration instead of traditional litigation, and boom, the tribunal hands down its decision and you win. Naturally, you're thinking it's time to pop the champagne, right? Just waiting for that check to clear. Well, as we're going to see from our source material today, winning an arbitration on paper, that's really only half the battle. The actual journey, the real finish line, is getting that award enforced. So today, we are completely demystifying Philippine arbitration laws. We're going to take all that dense legalese and give you a simplified breakdown of exactly how a piece of paper actually transforms into real-world results.
To keep things nice and simplified, we've broken this down into 5 easy chapters: enforcing the arbitral award, foreign versus domestic awards, grounds for refusing enforcement, the rules of the game, and finally, who pays the bill. Let's get to it.
Chapter 1. Enforcing the Arbitral Award. Let's look at what happens the exact second the arbitrators hand down that decision. So, looking at Chapter 6 of our source material, we learn that an arbitral award doesn't just magically enforce itself, sadly. A foreign arbitral award actually only becomes binding once a written petition is filed with the regional trial court or the RTC. Basically, you have to actively ask the Philippine legal system to recognize it, and you have to follow what are called the Special Alternative Dispute Resolution, or ADR, rules. It's kind of like bringing foreign currency to a local bank, right? You literally have to exchange it through the proper official channels before you can actually spend it. Moving right along to Chapter 2, Foreign versus Domestic Awards. The rules of the road actually change quite a bit depending on exactly where your award comes from. Now, the really crucial thing here is distinguishing between 2 types of foreign awards, convention and non-convention. So a convention award simply means the award was made in a country that's part of the New York Convention. That's a massive international treaty. If you've got one of these, you really just need to prove that the origin country is a member, and the Philippine courts will generally enforce it pretty smoothly. But on the flip side, we have a non-convention award. Now, if the country isn't part of the treaty, the Philippines might still recognize it, but it's based on 2 things: comity and reciprocity. And in simplified terms, comity is basically the legal version of mutual respect. The court is essentially saying, hey, we'll respect your country's legal decisions, assuming your country would do the absolute same for ours. So it's a bit more complex than a convention award, for sure, but still very much possible. But what if your arbitration didn't cross any international borders at all? Well, then you're entirely in the realm of domestic arbitration. And our source outlines a very specific framework for this. It's primarily governed by Republic Act No. 876, which is known as the Arbitration Law, along with specific sections of the ADR Act. But here is a really fascinating detail. If your dispute is specifically about construction, say you're building a massive new skyscraper in Manila, it gets its own special fast lane. That lane is governed by Executive Order No. 1008 under the Construction Industry Arbitration Commission, or the CIAC. It's a highly specialized system just to keep those building projects moving. Which brings us to Chapter 3, Grounds for Refusing Enforcement. Because naturally, the losing party isn't just going to hand over the keys without a fight, right? So what happens when they ask the court to just flat out reject the award? Well, the law is strict, but it's fair. The regional trial court isn't just going to blindly enforce an award if the process was fundamentally broken. The statutory reasons for refusal really boil down to just basic concepts of fairness. For instance, a court can refuse enforcement if a party was incapacitated, meaning they were a minor or maybe mentally incompetent when they actually signed the agreement. They can also refuse if a party wasn't given proper notice to present their case. That's kind of like being sued without ever receiving a letter in the mail about it. Or what if the arbitrators went totally rogue and made decisions completely outside the scope of what they were hired to decide? That's a ground for refusal too. And finally, if the tribunal itself was set up improperly and went against the agreed-upon rules, the court can absolutely hit the brakes. But wait, there is an ultimate legal trump card in Philippine law. Even if every single procedural rule was followed perfectly, even if everyone had proper notice and the tribunal was totally flawless, if the resulting award violates the public policy of the Philippines, the regional trial court will reject it. Full stop. Public policy acts as this broad safety net. It ensures that foreign awards don't force the country to enforce something that goes completely against its core moral, societal, or legal values. All right, let's transition into Chapter 4, the rules of the game. Because arbitration has some truly fascinating procedural quirks that make it vastly different from the standard courtroom drama you might see on TV. Let me pose a question directly from our source text. May arbitration proceedings be disclosed to the public? I mean, think about it. If two massive corporations are fighting over a $1 billion contract, can the press just sit in the gallery and report on the whole thing? The answer is a resounding no. Unlike traditional court cases, which are completely a matter of public record, arbitration proceedings, and that includes all records, all evidence, and the award itself, are strictly confidential. Our source clearly notes they cannot be published except with the explicit consent of the parties or for very, very limited court purposes. And honestly, this is a massive advantage for businesses. It protects sensitive trade secrets, proprietary research, and internal processes from being leaked to competitors right in the middle of a dispute. Now, here's a fact from our sources that almost always surprises people when we talk about legal representation. In a traditional Philippine court, your representative absolutely must be a licensed lawyer who is admitted to the practice of law. But in international commercial arbitration conducted in the Philippines, a party may be represented by literally any person of their choice. Yeah, you heard that right. As long as they aren't appearing in a formal Philippine court or a quasi-judicial body outside of the arbitration, your representative doesn't strictly have to be a licensed attorney. So, theoretically, you could have an engineer represent you in a deeply technical engineering dispute. How cool is that? Okay, but what if you lose and you really want to appeal the regional trial court's decision to recognize the award? Well, appealing involves taking the RTC's ruling straight to the Court of Appeals. But there is a massive catch here. The appellant, the loser, is legally required to post a counterbond executed in favor of the prevailing party that is exactly equal to the amount of the award. Think about that for a second. If you lose a $10 million arbitration, you have to put up a $10 million bond just to file the appeal. It's a huge hurdle, purposefully designed to prevent sore losers from using endless appeals just to delay paying up. Furthermore, our sources explicitly state that parties can agree in advance to lock the doors entirely. You can literally put a stipulation in your contract that the arbitral tribunal's decision is final and unappealable. Now, there is a tiny caveat to this. Even with that stipulation in place, the rules still preserve a constitutional safety valve. It's a special judicial review called certiorari. But that is strictly reserved for extreme cases where there's been a grave abuse of power. For all normal intents and purposes, though, you can totally agree to make the tribunal's word the absolute final say. Okay, let's dive into our fifth and final chapter, which is perhaps the most highly anticipated part of this whole journey. Who pays the bill? So arbitration isn't just paying an hourly rate to a judge. The total arbitration bill is actually made up of several distinct components, perfectly outlined in Article 4.46 of our source text. First, you have tribunal fees. These are carefully calculated based on the sheer amount in dispute and the complexity of the case. Then you have expenses, meaning you have to cover the travel and the accommodations for the arbitrators and sometimes even the witnesses. Then there are extras, things like fees for hiring specialized experts or appointing authorities. And finally, legal help. If the winning party asked for their legal costs to be covered, those will be paid out, provided the tribunal thinks the amount is fair. It adds up extremely quickly. So who actually writes the check? Well, the general rule, simplified straight from the statute, is pretty straightforward. The losing party is responsible for paying the arbitration costs. Simple as that. If you bring a claim, force the other side into a hugely costly arbitration process, and then you lose, you are generally going to be the one footing that entire massive bill we just looked at. As you can imagine, this heavily discourages frivolous claims. But as with literally all things in law, there is an exception. The arbitrators possess the flexibility to divide or apportion the costs between the parties if they determine that splitting the bill is reasonable based on the specific circumstances. Maybe both sides won some parts of their arguments and lost others. Ultimately, the tribunal has the final say in making sure the financial burden is distributed fairly. Which leaves us with this final thought for today. We've seen that transforming an arbitral award into actual reality requires navigating regional trial courts, proving international conventions, dodging massive counterbonds on appeals, and footing potentially enormous bills. Given these strict rules and tough enforcement hurdles, you really have to ask yourself, is the absolute privacy and the specialized speed of arbitration truly worth that final price tag when compared to traditional public litigation? It's a complex calculation for sure. But hopefully, this explainer has given you the simplified, structured understanding you need to weigh those options for yourself. Thank you so much for joining me to demystify Philippine arbitration today. Keep learning, keep focusing, and I will see you in the next explainer.